Good morning, everybody, and welcome to this month's Family Law Roundup, coming to you from a very, very cold Johannesburg. Good morning, Renal. Good morning, Eugene. Great to see all of you in today. I look forward to spending a good hour and a half with all of you, chatting about some of the most interesting cases in the realms of family law in the last month or so. I've got a good 18 cases that we will be running through today to get us all caught up on what has been happening in the courts throughout South Africa in the realms of family law. Right, so before we get into the family law cases, let's quickly run through some admin. First off, very, very warm welcome. As I mentioned, for those joining us for the first time, my name is Mervyn van Meulen. I am an attorney, and this is a bit of a passion project of mine to run through our case law every month for your benefit. For more information, please visit thinklegal.co.za. There you can register for events, join our WhatsApp groups, you can purchase resources, and you can view past webinars. So what is ThinkLegal? ThinkLegal is an initiative by Van Meulen attorneys which aims to promote the open sharing of sound legal knowledge. While we acknowledge that the delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. ThinkLegal, as always, supported by Van Meulen attorneys and Lawbox practice management software for lawyers by lawyers. To get Lawbox, visit lawbox.co.za and get 14 days free Lawbox subscription to take it for a test drive. Great, folks. So without any further ado, let's get into the roundup. As I mentioned to you, I've got 18 cases for us to run through. We've changed the slides this week a little bit, but hopefully it will not detract from the experience. So for those, incidentally, who would like to purchase the course pack, it is absolutely voluntary. As always, it is $250. Then you get our summaries, you get the bundle of cases discussed, and you get 2 CPD points underwritten by SAM and Social Justice Association of Mediators, being NABFAM bodies. So I've posted the links for those who would like to pick up the course packs. So guys, first off, we are headed down to the Western Cape for the matter of RS versus JS. Your full citation, SAFLI citation, not on your screen, so please listen up. A25/2024, and that is 2024 ZAWC HC 154. That is from the pen of Lekuleni J and Bishop AJ concurring. Bundle page 1 for those of you who are following along. This matter, as the slide shows, deals with the issue of maintenance, and specifically we are dealing with a matter where there was a foster child and there was incomplete adoption proceedings. The matter went on appeal from the maintenance court, and the matter dealt with the legal duty of a divorced foster father to continue maintaining his foster child, despite the fact that the adoption proceedings had not yet formally been finalized. The lower court made the decision to absolve the first respondent from his duty to support the child on the basis that the adoption had not been completed, and this was then taken onto appeal to the Western Cape High Court. The High Court found that the respondent had voluntarily assumed parental responsibilities and rights towards the child, who had developed a significant bond with him, and the appeal was essentially upheld, edifying the fact that the respondent had a duty to support the child, even though the adoption was not yet finalized. The judgment deals with Section 28.2 and Section Section 28.2 of the Constitution, apologies, and Section 7 of the Children's Act, being the best interests of the child standard. Then it deals with informal adoptions and consequences of those informal adoptions. That's paragraphs 29 to 31. And it talks about a concept of de facto adoptive parents in a case where the de jure adoption had not yet been finalized, who have a duty to support their putative adopted child. Very nice quote from the judgment can be found at paragraph 42. By parity of reasoning and considering the child's best interest, there is no reason, in my view, for excluding a de facto adopted child from the benefits of the duty of support conferred upon other children in terms of adoption contemplated in Chapter 15 of the Children's Act. Equity in this context is justified by the child's constitutional rights to proper parental care and the child's best interests as encapsulated in Section 28 of the Constitution. Then paragraph 43 continues to say, I accept that the common law does not recognize the duty of support between children and adoptive parents, and that this duty has been introduced into our law in terms of statute. However, I am of the view that the best interest of the child is paramount and must prevail. It demands and cries loudly for the protection of informally adopted children in circumstances like this case. Simply put, the duty of support that applies to formally adopted children, in my view, can apply with equal force in informal adoption, where the duty of support has, like here, been established by the parent's conduct in that case. That was RS versus JS, all the way from the Western Cape High Court under the pen of Lekuleni J. Thank you so much. Dion Reuters says, I'm happy to report that for June, I summoned Mr. JS on a Section 9.2 summons for 25 June with a copy of the High Court judgment. Both of them were at Kuilsrivier Court, where Mr. JS confirmed the High Court order of 5,000 Rand and agreed on a consent order to the 5,000 Rand and 80,000 Rand lying in expenses. Very, very good news there. Nice to see where the matter had gone. Thank you so much for the feedback. Dion, I appreciate it. Right, folks, 1 down, 17 to go. Next up, we are headed to the North Gauteng High Court in the matter of LL versus AJM and others. Safley citation 2024 ZAGPPHC 523. This judgment landing on the 7th of June 2024 under the pen of Neukircher J. That is in your bundles on page 29. Now, this judgment, folks, deals with the obligation of a deceased estate to maintain minor children and essentially edifies the principle that the obligation to maintain minor children extends to the deceased estate of a parent. As you will all know, last month we covered another judgment by Neukircher J in respect of an interim maintenance claim where the child was in a care home due to special needs, and Neukircher J taking a very robust child-centered approach in that case. And in the same instance, she took a very robust approach in this matter. So essentially what happened in this instance was the following. The minor children were the sole heirs of a deceased estate. The mother, in her capacity as guardian, brought a claim against the deceased estate for maintenance, which was declined by the executor based on principles set out in one of our seminal works on deceased estates, being Meyerowitz on deceased estates. And the matter then went to the North Gauteng High Court. The executor launched an exception saying that the mom has made out no case that she is not able to maintain. The children are essentially the sole heirs of the deceased estate, so the claim is bad in law. The court decided that the claim is not bad in law and that the issues of affordability, etc., needed to be ventilated at trial, and the exception was then dismissed with costs. A notable quote is from paragraph 20 of the judgment, where Neukircher J states, if the executor steps into the shoes of the deceased and he assumes the maintenance obligations of the deceased, it stands to logic that the principles generally applicable to maintenance claims for minor children must be applied, i.e., that the duty of support falls to both parents according to their means. What their means is informed by the evidence placed before the court at the time of the inquiry and on the executor in accordance with his duties to utilize the assets, finances, and income of the deceased estate to maintain the children in accordance with the general principles applicable. This judgment marked of interest to other judges and reportable by Neukircher J. I will report to you in a few months whether it has in fact made its way to the law reports. That was LL versus AJM and others, dated 7 June 2024, Neukircher J, bundle page 29. Next up, folks, we are going into a relocation matter. And what is interesting about our relocation matter today is that the relocation was to a non-Hague Convention country. The matter in question, folks, NN versus SMA, Safley citation 09376/2023, 2024 ZAGPPHC 504. This being under the pen of Retief J and landing very, very early in June. For those following along in the bundle, please go to page 45, where you will find the judgment of Retief J. Now, what does this matter revolve around? As mentioned previously, it is a relocation to a non-Hague Convention signatory country. In other words, there is no mechanism to bring the child back to South Africa if the child is wrongfully removed to Cameroon, being the country in question, or wrongfully retained there. The case was brought by a father to gain primary care of his minor son, and then also the permission required to relocate to Cameroon. The mother, who was the primary carer or primary caregiver, had passed away, and the child had in the interim been cared for by the maternal uncle. In deciding whether to grant primary care and consent, obviously, to relocate with the child, the court considered, firstly, as in all of these cases, the best interest of the child, particularly his feelings of abandonment and the need for attachment to his father. The aspects covered in this judgment, as in all matters involving children, Section 28(2) of the Constitution and Section 7 of the Children's Act. The court makes a point of setting out in paragraph 10 of the judgment that each matter is case-specific, as we know is the case with these types of relocation matters. The court went into quite a bit of detail from paragraph 16 to 20 on the issue of child participation and its relevance to the issues of relocation. And then finally at paragraph 25, the court looked at the Hague Convention, which is obviously also, whilst this is not a Hague Convention application, relevant to the adjudication of the matter. The outcome essentially was that the relocation was granted, but the court also dealt with various practical issues, including parental guidance and attachment therapy, considering that the child was not primarily resident with his father post the passing of his mother. An interesting quote is in paragraph 26, and I think, let me read it out for you. It's quite a lengthy quote, but please do bear with me. Having regard to all the evidence to discern the needs and the interest of S, who's the child, and applying section 28 of the Constitution of South Africa, this court exercises its discretion in favor of the applicant. Having said that, this court too considers the time triggers of the respondent as well as the inability of the respondent to act as S's guardian during such time. The respondent's family needs to remain in contact with S. The applicant and S's need to reunite with the assistance of a social worker here in South Africa, and Advocate Steenkamp's recommendations pertaining to the commencement of the school terms in Cameroon is noted with thanks. Prayer 4 to be done before the new school term starts in Cameroon in September 2024, and to be continued in Cameroon if so indicated. And this obviously referring to various of the practical implications that the court looked at in terms of bonding, etc. That was NN versus SNA under the pen of Retief J, bundle page 45, Pretoria High Court. Next up, folks, we move to care and contact. And for this one, we are moving all the way down to the Western Cape, which, if the comments are to be believed, is just as cold as Gauteng is at the moment. The matter in question, DR versus NM and another, 3358/2024, 2024 ZAWCHC 165, judgment dated 7 June 2024. This was also under the pen of Lekuleni J, and this is in bundle page 54. This was an application for leave to appeal against the appointment of the family advocate to investigate care and contact. The application for leave to appeal was brought by the first respondent, and it was against a court order directing the Office of the Family Advocate to conduct a care and contact assessment of minor children to determine their best interest. The applicant challenged the first respondent's parenting and mental functioning in this matter. What was looked at in this case? As always, best interest of the child, section 28.2, as we know, and that's paragraph 16. The High Court's discretionary power as the upper guardian of children to ensure their best interest, paragraph 21. And then an interesting discussion in paragraphs 14 to 15 on the conditions for granting leave to appeal under section 17 of the Superior Courts Act, and then also some discussion on the nature of interlocutory orders and their appealability. The application for leave to appeal was dismissed. The court says in paragraph 2022, no, not that many paragraphs, in paragraph 22, that as an upper guardian of all dependent and minor children, this court has an inalienable right and authority to establish what is in the best interest of the children and to make corresponding orders to ensure that such interests are effectively served and safeguarded. No agreement between the parties can encroach on this authority. The court making it very clear that the High Court is the upper guardian. Next up, we go to an appointment of a curator ad litem, and that is KT and others versus JNT and another, 056992 of 2024, 2024 ZAGPP HC 536. This judgment dated 13 June 2024, and this is under the pen of Wesley AJ in the North Gauteng High Court. For those following along in the bundle, you can find the judgment at page 69. Now, this was an interesting matter where the eldest siblings of a minor child sought the appointment of an advocate as a curator ad litem for the child. The purpose of the appointment of the curator was in arbitration proceedings concerning the administration of a family trust and any subsequent litigation. The first respondent, their mother, opposed the application on the grounds of urgency and obviously delving into the merits itself as well. In this instance, the court looked at the criteria and the legal considerations for appointing a curator ad litem and restated the principles of Legal Aid Board in Re for Children 2011 JOL 27159 from the Supreme Court of Appeal. Further, there was an interesting juxtaposition of the powers and obligations of guardians as set out in Section 18.3 of the Children's Act versus the powers and obligations of a curator ad litem. Ultimately, the application was granted with costs. So the eldest siblings were successful in appointing a curator ad litem for their younger sibling, and their mother's opposition was unsuccessful. A notable quote from paragraph 1 of this judgment, Wesley AJ says, "It is trite law that this court, in its inherent jurisdiction, is the upper guardian of all minor children with authority to determine what is in their best interest. Section 28.2 of the Constitution, 108 of 1996, provides that a child's best interests are of paramount importance in every matter concerning the child. The Constitution accordingly makes it clear that in matters concerning a child, the court must adopt a child-centered approach." Very interesting quote by Wesley AJ. Nothing that we don't know already, but very concisely and succinctly set out. That was KT and others versus JNT and another, all the way from Pretoria, Wesley AJ, bundle page 59. Next up, we go on to the adjudication of several points of law in respect of a customary marriage, staying in the North Gauteng High Court, and the judgment by Marumukhai AJ, quite a lengthy judgment, as Marumukhai AJ is inclined to write for those who are regulars on the Family Law Roundup. The judgment approximately 40 pages in length and quite an in-depth read. Citation, it is JRM versus VVC and others, case number 25007/2022. At time of preparation for the Family Law Roundup, this judgment was not yet on SAFLI. However, those of you who have purchased the bundle can find it at bundle page 76. Now, what was interesting in this matter was the issue of an antenuptial contract, which was entered after the customary marriage and before the civil marriage. Now, you will recall, those who were here last month, there was a matter where the court also had to determine this, but came to the conclusion that neither party intended to get married. Even though they did the customary rites, they always intended to do the civil marriage and to appease their families by going through the customary rites. And the judge in that case saying that it's not uncommon in customary law for this to happen. This case, however, is distinguishable. In this case, it would appear that the parties were at idem that there was a customary marriage, and in this instance, the court looks at Section 10.2 of the recognition of customary marriages. Now, what had happened here was the parties entered into a customary marriage some time back, then at a later stage entered into an antenuptial contract, and then entered into a civil marriage. The court was then called upon to decide whether the antenuptial contract purporting to essentially change the matrimonial property regime from in community of property to out of community of property was valid. And essentially, the court looked at the following principles. First off, we know customary marriages, unless excluded by ANC, are in community of property. Then we also know under Section 21 of the Matrimonial Property Act that judicial oversight is required when changing one's matrimonial property regime. We all know this is quite an onerous application where you have to cite all and sundry and get consent, or you need to get a court order first to enter into the further notarial contract. Then Section 10 of the Recognition of Customary Marriages Act allows spouses in a monogamous customary marriage to marry each other under the Marriage Act without judicial intervention, sections 10.1 and 10.2. The court decided that Section 10.2 of the Recognition of Customary Marriages Act is inconsistent with sections 9.1 of the Constitution and invalid to the extent that it permits the conclusion of contracts that seek to change the parties' MPR and thereby regulate their proprietary consequences after a customary marriage without judicial oversight. Section 10.2 of the customary marriages is declared to be inconsistent with Section 25.1 and invalid to the extent that it permits arbitrary deprivation of financially weaker spouses' ownership rights over the assets that form part of their joint estates. Now, whether the subsequent civil marriage or the entering into of an antenuptial contract is the triggering event that changes the matrimonial property system of the parties is a question for another day. Essentially, we know from a whole line of cases that if there was a valid customary marriage and a civil marriage following it, that the civil marriage is then also deemed to be in community of property, and the antenuptial contract is simply pro non scripta and invalid. In this instance, however, the court went as far to say that Section 10.2 of the Recognition Act is unconstitutional. Now, bear in mind, folks, that this first needs to be confirmed by the Constitutional Court. However, it will be interesting to see whether the Constitutional Court follows suit with Morimukhai AJ from the Pretoria High Court. Interesting quote, paragraph 102 of the judgment: spouses in monogamous civil marriages have legislative protection that spouses in monogamous customary marriages do not have, and that amounts to differentiation. While there is no legislative bar on persons from any other races to enter into customary marriages, these types of marriages are concluded by mainly Black South Africans. Even though this category of people is not prohibited from concluding civil marriages when they have concluded monogamous customary marriage, they are treated differently. The issue is also gendered by its very nature. It is mostly women, as argued by the first defendant, supported by the amicus curiae, who are financially prejudiced when their monogamous customary marriages are changed into monogamous civil marriages and they are later divorced. That being the case of JRM versus VVC and others, case number 25007 of 2022, Pretoria High Court, under the pen of Morimukhai AJ. Next up, we go into the realms of divorce and forfeiture of patrimonial benefits. Something we don't see very often is a divorce ruling from the Pretoria High Court, as we know that we are faced with quite a lot of heavy lead times in the Gauteng courts, and we don't, for that reason, in my view, see as many divorce judgments from the North and South Gauteng High Courts. But here we have one under the pen of Neukircher J, which you can find at page 118 of your bundle, Safley reference 2024 ZAGP PHC 516. It was a contested divorce action. The plaintiff sought maintenance and the division of the joint estate, while the defendant pursued forfeiture and the plaintiff's share in her pension benefits. The court examined contribution, and we see quite a lot of contribution being considered by the courts in making forfeiture orders. And the question is begged in terms of Section 9.1, which only makes provision for duration, misconduct, and circumstances which gave rise to the breakdown of the marriage, whether there isn't scope for this issue of contribution to be imported into our legislation somehow. But that is not for me to decide. It is, however, an interesting question to ponder. Forfeiture of patrimonial benefits is governed by Section 9.1 of the Act, as you know. It allows the court to order forfeiture if one party would be unduly benefited without such an order. The undue benefit is determined by looking at the duration, circumstances leading to the breakdown of the marriage, and any substantial misconduct of the parties. However, as I mentioned, a lot of judgments coming out now, the courts look at contribution. So paragraph 21 of the judgment, very notable. Here, plaintiff is adamant he is entitled to half of the value of the joint estate, simply by virtue of the fact that the parties are married in community of property. Whilst this is legally correct, in my view, he will be unduly benefited were the forfeiture order in respect of defendant's pension benefit not be granted for the following reasons. Now, very important, folks, we have seen some controversy and skirmishes where one party says, well, we were married for 20 years, and another party says, well, we were actually just together for 5. So in fact, it was only 5 years. And the argument has raged previously, whether you take the 20 years or just the time that the marriage was de facto a functioning marriage. Here, Neukircher J specifically sets out that whilst on paper the marriage lasted 24 years, in reality, it lasted just 6 years, which is very important for those dealing with forfeiture claims where there are marriages of long duration, where, for example, the parties stopped cohabitating or were estranged at some point during the marriage and never went through with a divorce. B, the plaintiff simply failed to support his family properly and in the last 4 years completely. The idea of contribution and support very strongly coming in. The defendant has clearly throughout the marriage not only been the breadwinner, but has gone above and beyond to earn whatever small extra income she can to support her family. So squarely looking at duration and de facto duration, not the full duration of the marriage. And then paragraph 23, very importantly, Neukircher J says, I emphasize as fairness or equality play no part in the determination of forfeiture. The sole factors taken into account were those set out in section 9.1, being duration, misconduct, and circumstances which gave rise to the breakdown. And presumably the argument is made that the lack of contribution constitutes a misconduct. Very interesting judgment under the pen of Neukircher J, NCN versus GMLN 1629-2022, and that is 2024 ZAGP PHC 516 Safley reference. Right. Next up, we move on to the matter of MT versus ET, which is also a divorce matter emanating out of the South Gauteng High Court. This judgment under the pen of Brunt, AJ, bundle page 127, Safley reference 2024 ZAGPJ HC 578. For those of you who are interested, I'm almost going cross-eyed looking at all of these abbreviations on all of our case names. I really do miss the days where it was a surname to remember and not these very, very convoluted initials, but obviously under POPI, we must protect the identities of the parties to the litigation. So, what happened in MT versus ET? The parties were married in community of property. The divorce and the division of the joint estate was common cause between the parties, was agreed upon. However, the plaintiff requested rehabilitative maintenance for the defendant, whereas the defendant wanted lifelong permanent maintenance and other specific benefits. The court was called upon to determine the nature, amount, and duration of the maintenance, as well as other claims related to medical aid and pension benefits. The court looked at Section 7.2 of the Divorce Act. As we know, this is our Bible when it comes to spousal maintenance claims. It sets out the factors considered and the broad legal framework. The court sets out in paragraph 11 that it must consider the means, earning capacities, financial needs, and obligations of the parties, the duration of the marriage, the standard of living prior to the divorce, and conduct related to the breakdown of the marriage. Then in paragraph 12, the court, per Wesley AJ, makes it clear that the court aims to balance fairness when fairness and justice, considering all the relevant factors. The notable quote in this judgment can be found in paragraph 12, which says, these factors listed in section 7.2 must be considered by a court determining what is just concerning maintenance. And a court may also consider other factors it considers relevant. As we know, section 7.2 has the provision for any other factor, which is often confused with section 9.1 of the same act, which does not have such provisions. Overall, the factors that are considered must be taken together rather than in isolation to determine what is just in the circumstances of the particular case. The court must form a holistic view of the matter, in other words. Overall, the court must endeavor to reach a resolution that is fair or just to both parties in the circumstances, taking account of the need for maintenance of the party claiming it and the capacity of the other party to pay it. What happened with this matter all the way from Pretoria under the pen of Brand AJ is the following, and I'm going to actually read to you from the judgment itself. The court found that there shall be division of the joint estate. 50% of the pension interest was granted. Then paragraph 7 of the order, the plaintiff shall pay maintenance to the defendant at the rate of 40 grand per month on or before the first day of every month until death or remarriage. So the plaintiff in this instance, or the defendant in this instance, was successful with lifelong maintenance against the plaintiff. Next up, folks, I'd like to just remind all of you to visit thinklegal.co.za for some more information regarding ThinkLegal and what we do in terms of our initiative. My apologies. Sure. Cold Friday morning, my brain just seized up momentarily. You can register for events, join WhatsApp groups, purchase resources, and view past webinars. That's thinklegal.co.za. Just a reminder for those of you who would like to find yourself in possession of the course pack, you are welcome to purchase it from our Shopify page link, which has been posted. If you are struggling with Shopify, please do email me. I've put my email on. One of our attendees says they appreciated when the paragraphs were on the screen. We have tried this month to rather not do that, since we have been having some problems with screen grabs etc., and people copy pasting our hard work. So we will reconsider that. But for those who would like to see the quotes as well, they are in the summaries, which look like this. I'll share this one with you. This is essentially what the summary looks like, with your citation, court overview, aspects covered, outcome, and then notable quotes. So for those of you who would like to pick that up and also get yourself 2 CPD points from SOM or social justice, please go to our Shopify page. Right, next up, we are in the Cape, and we are dealing with a Hague Convention matter, ad hoc central authority for the Republic of South Africa versus DM. This was under the pen of Klute J. You can find it in your bundles on page 141, and your full citation, ad hoc central authority for the Republic of South Africa and another versus DM, 2024 ZAWCHC 170, and this is 19 June 2024. Now, this deals with the application for the return of a minor child, or minor children at least, to Germany. It looks at an Article 13B defense, and it also looks at what constitutes the habitual residence of the children. So what had happened is the father contended that the family had permanently relocated to Germany, but the mother, who was keeping the children in South Africa, disputed this. The court had to determine whether Germany was the children's habitual residence, and it also had to look at whether the mother could establish a defense under Article 13B of the convention. Now, Article 13B, as some of you are aware, is the exception for when children need to be returned under the convention, and certain specific factors which are taken into account. Now, what was important from ad hoc central authority versus DM is that the court looked at the necessity of proving habitual residence before triggering the provisions of the Hague Convention. If you do not prove that the children were habitually resident in the country to where you wish them to be returned, you do not get out of the starting blocks, because the convention is not triggered. The court looked at the Plascon-Evans rule, as I'm sure all of you are familiar with, and the court obviously looked at Article 13B and whether the mother had established a 13B defense. Jennifer, thank you so much for your feedback, saying that the summaries are so useful. I really, really appreciate it, and I hope you enjoy reading it as much as I like preparing it. The application was dismissed. The 13B defense ultimately becoming moot because the court found that the father had failed to prove habitual residence of the children in Germany, and thus the Hague Convention was not triggered. Paragraph 7 of the judgment, notable quote, "It is accordingly the requirement of habitual residence in Germany prior to the children's unlawful retention in South Africa upon which this case falls to be determined in order for the convention to apply. Further, if habitual residence in Germany is established, it must be decided whether the mother's belated Article 13B defense, not advanced in her papers but only in her heads of argument and annexures thereto, withstands scrutiny." What is also interesting is the brief investigation of Klute J, or summary of Klute J, of who bears which onus of proof. The father claiming habitual residence bears the onus of proof in respect thereof, and the mother, who wants to establish the 13B defense, bears the onus of proof in respect thereof. The court not only dismissed the application for the return of the children to Germany, but actually went further and made certain other orders. Inter alia, the passports of the children were to remain with the central authority in South Africa. Contact arrangements. Well, that's frustrating. Let's see if we can get back in. Hello, everybody. Can someone please comment whether they can still hear me? I do apologize. We had some issues with our electricity at the office park, and I was disconnected for a moment. Great. Okay. I see Nadia says you can hear me. Let me. There we go. I'm back. And this is why we pay premium price for office space with presumably backup power. Sorry about this, folks. I hope that you can hear me and see me now. And I'm back, if a bit rattled, at least present in spirit and physicality. Let's have a look. Can't hear me anymore. All right. Let's see. Nadia, can you hear me? All good now. Okay. Thank goodness. Someone just gave me a light heart attack there. Sure. Right. Let's go. A little bit wobbly, but let's proceed. Next up, we have CAR versus Central Authority of the Republic of South Africa, and another. This is all the way from the Supreme Court of Appeal, and the judgment penned by Molemela P and Mokumi ADP, page 318 of your bundles. For those following in the bundles, please forgive me. I realized quite late last night that this judgment had not made its way to the bundle on the system, and I just added it. So I will redistribute this to everybody who requires. This matter, dealing with the Hague Convention, there was an Article 13B defense. Now, what had happened here was an application was launched by the Central Authority and the father for the return of a minor child to Canada. The High Court in Pretoria dismissed the application in terms of the Hague Convention, and the matter was taken on appeal to the Supreme Court of Appeal. The core issue in this instance was whether there was a grave risk of harm to the child if returned to Canada, as argued by the mother under Article 13B. Now, as you know, an Article 13B defense saddles the person raising the defense with the onus of proof to prove that there is this grave risk of harm. The judgment looks at Article 13B, as I mentioned, of the Convention, which allows for the refusal of a child's return if it is shown that there is a grave risk of physical or psychological harm or otherwise placing the child in an intolerable situation. The appeal was upheld an order was granted for the return of the child to Canada with specific protective measures put in place. A notable quote from this judgment, folks, is the following. It is clear that what constitutes the risk of harm will be determined by the facts of each case and the nature of the projected. We are dealing with a severe risk of harm towards my landlord as a result of this morning. Can I please ask a good Samaritan just to confirm whether everyone can hear me, please? Thank goodness. Okay, everyone can hear me and everyone can see me. I hope that that sustains. I'm going to proceed. I've taken my laptop out of its dock now, so the camera is not going to be as nice, but at least we know it is going to stay on whilst my office park pulls itself towards itself. As I mentioned, a grave risk of harm to our landlords at the office park as soon as we conclude this webinar. Not sure the Hague Convention will apply. However, in CAR versus Central Authority, a notable quote, it is clear that what constitutes the risk of harm will be determined by the facts of each case and the nature of the projected harm. Although a child's best interests are central to legal decisions involving children in the context of an application for a return order premised on the Hague Convention, the Hague Convention presupposes that the child's best interest is served by their prompt return to their country of habitual residence. As such, the concept of the best interest of the child must be evaluated in the light of the exceptions set out in Article 13b of the Hague Convention. A court that is considering an application for a child's return premised on the Hague Convention must not only consider the allegations of a grave risk for the child in the event of the granting of a return order, but must also consider any undertakings made by the applicant parent in an effort to obviate the eventuation of that harm. We know that on the international level, the idea of undertakings and safeguards have been under quite a lot of scrutiny. That was, folks, and I don't have a dual screen anymore, so please forgive my alt tabbing, CAR versus Central Authority of the Republic of South Africa, and another 2024 ZA SCA 103 under the pens of Molemela P and Mukumi ADP. Rightio, next up, we are going to, and I'm going to make myself smaller because I don't have the nice camera anymore. We're looking at interdicts, and starting us off is KSL versus AL, where we encountered a fairly irate Supreme Court of Appeal under the pen of Mokhohloa JA, and that is on page 177 of your bundle. The full citation, folks, KSL versus AL 2024 ZASCA 96, and this judgment landed on the 13th of June 2024. This judgment looks at an anti-dissipation interdict and the requirements thereof or therefore. The Gauteng Division of the High Court decided to grant an interim anti-dissipation interdict pending divorce. The respondent sought to prevent the appellant from dissipating assets, specifically the proceeds from the sale of immovable property, to secure her accrual claim. The court looked at the requirements for an interdict, but the court went further and looked at the requirements for Knox de Arce relief, which obviously refers to that case which was adjudicated in the SCA, which introduced a further requirement for anti-dissipation relief in the form of intent. So not just the grounds for a normal interdict, but also this further requirement of intent. The court looked at whether a Rule 34 tender amounts to an acknowledgement of liability, and then once again, as in many of these matters, the court did a discussion on appeals in interim orders in terms of the Supreme Court's Act. The appeal was upheld and the anti-dissipation order was set aside. And interestingly, in paragraph 29, the SCA sets the record straight and almost repeats itself, saying, as stated above, JLT and the cases that follow it do not reflect the correct legal position. Knox de Arce, a decision of this court, settled the matter on the requirement of intent in anti-dissipation applications. The high courts were bound to follow the decision of this court, which is precedent. Following precedent is not simply a matter of respect for higher authority, it is a manifestation of the rule of law itself, which in turn is a founding value of our Constitution. The SCA essentially saying, we've made the position clear in Knox de Arce. The high courts have not followed the position. They have been incorrect in not so following it. This is the position, and they are bound to follow it going forward. So KSL versus AL, folks, I think is one of these NB cases to have in your arsenal as a family law practitioner in respect of anti-dissipation interdicts, where you do not merely have the requirement for an interdict, but the further requirement of intent as set out in Knox de Arce. That was KSL versus AL and another. KSL versus AL, not another, just KSL and AL, 2024 ZASCA 96, page 177 of your bundle. Next up, we go into the realms of procedure, and we look at SB versus BB and another, and this is an interesting judgment from the Eastern Cape High Court, 2024 ZAECMHC, and that is 4th of June 2024, under the pen of Kunju AJ, sitting in the Mthatha High Court, the bundle page 195. I have an interesting phenomenon in my office, ladies and gentlemen. If something goes wrong or something goes amiss, the person responsible is dead. And that is exactly what happened in this matter. The matter deals with whether there was a valid customary marriage. So the applicant in this case brought an application to nullify his civil marriage to the first respondent, asserting that it was invalid due to a prior customary marriage with another woman. The applicant claims that the customary marriage involving traditional rituals and payment of lobola took place in 2010. However, the wife cannot be found and everyone involved had died. The respondent contests this, alleging that it's a fabrication to avoid the consequences of divorce, particularly the division of the joint estate. The judgment looks at the validity of a subsequent civil marriage during the subsistence of a prior customary marriage. It looks at the weight of evidence in proving the customary marriage, and then it also looks at the application of Rule 65G for referring an application to oral evidence, where there are factual disputes which are unresolved in affidavits. The matter was referred to oral evidence. the only course of action, I suppose, that the court could take. And the court saying, the common thread in this matter is that everyone who allegedly played a significant role and who could shed some light about the existence or otherwise of this marriage is deceased. Very convenient. Something is shrouded in the dark, and that is from paragraph 4, and very interesting, just to take note of the fact that the matter was referred to oral evidence and the grounds for referring a matter to oral evidence under Rule 65G. Next up, we go back to the SCA in VJ versus VJ and another 258 of 2023, and that is 2024 ZA SCA 92, and that was on 11th of June 2024, and that is under the pen of Kwele J.A. I don't have the quorum details here, but you will find it in your bundle on page 161 if you would like to work through it yourself. Now, what is interesting in this matter is it deals with an arbitration clause. Now, when you are in the realms of family law and you see an arbitration clause anywhere, you should, with very cautious ire and intent, move forward, because we know that Section 2A of the Arbitration Act prohibits the arbitration of matrimonial causes or any matters incidental thereto. You cannot arbitrate a family law or a matrimonial matter, including divorce or anything flowing therefrom. The question was whether arrear maintenance can be subject to arbitration under Section 2A of the Arbitration Act. The appellant sought enforcement of a maintenance order in the maintenance court, which the first respondent argued should be arbitrated as per their deed of settlement, which contained an arbitration clause. The High Court initially ruled in favor, upholding the arbitration clause. The matter was taken on appeal to the SCA. Obviously, this judgment looks at Section 2A of the Arbitration Act, which prohibits arbitration of matrimonial causes or matters incidental thereto. Looks at maintenance disputes, especially arrear maintenance, and whether these are considered incidental to matrimonial causes and thus not capable of arbitration. Looks at the Maintenance Act, which provides a specialized jurisdiction to maintenance courts, ensuring that such matters are handled within the judicial system to uphold public policy and legislative intent. Right, I'm sure everyone is waiting with bated breath, and I will tell you the appeal was upheld. You cannot arbitrate arrear maintenance. The court stating at paragraph 29 of the judgment, from the above analysis, it cannot be contended that the ensuing arrear maintenance, including the enforcement of the order, are not connected with a matrimonial cause or are matters incidental thereto. In other words, they are absolutely matrimonial causes. Section 2A of the Arbitration Act is wide enough to keep such matters out of the field of arbitration. Dion saying the VJ matter is so important for mediators compiling mediation agreements and should be part of all training curricula. Here, Dion, I agree 100%. Very, very important. You cannot bypass the jurisdiction of the maintenance court. And I'm certain, Dion, what you're referring to is also not just the fact that it is an arbitration agreement, but potentially a mediation agreement as well, which we see so often, parties saying that before we litigate in respect of any aspect, we will first try to mediate. So that was BJ and versus VJ and another SCA under the pen of Kwele J.A. Folks, I have 5 more judgments for you, 26 minutes to go. I should get you home and dry no later than 10:30, despite our technical hiccups, for which I apologize once again, and find it germane to point out that since our last hiccup, the power has been on beautifully. So that makes it even more infuriating. Next up, we go to KwaZulu-Natal. This is not a new judgment. This is under the pen of Henriques J. From the Durban High Court. This is a judgment which was unreported up to now and has been reported in the fourth edition of the SA Law Reports, WB versus RB and another, 2024 for SA 316, and this a critical judgment to those dealing with care and contact disputes, especially where one party wishes to impugn or impose on the privacy of another party in seeking medical records. Essentially, what the matter deals with is a subpoena for medical records pertaining to the mental health of the first respondent in a primary residency case. The applicant sought disclosure of medical records from the Riverview Manor Specialist Clinic in the context of a dispute over primary residence. The first respondent obviously opposed on the grounds of privacy, privilege, and jurisdiction. The court balanced the competing rights of privacy and the best interests of the children. The High Court had a hell of a time in this case, which is understandable, in balancing two competing rights under the Constitution. Section 28(2), which says that the best interests of the child are paramount, and Section 14D, which grants the right to privacy under the Constitution. So two competing constitutional imperatives. The court also looked at the confidentiality of medical and information under the National Health Act 61 of 2003 and Section 14 thereof. And essentially, the ratio in this matter entailed the court weighing up the need for access to medical records against the privacy interests of the individual. Now, what happened is the court tried to protect the privacy of the first respondent, obviously also taking into account that the records sought may be very relevant in the context of the litigation. So the court ordered Riverview Manor to provide a medical report to a clinical or forensic psychologist appointed by the applicant. Very importantly, the court did not order them to give the information to the applicant, but to a clinical or forensic psychologist. Now, obviously, we know that there is some controversy about forensic psychology as an area of practice under the Health Professions Council, but it's quite clear what the court had in mind there. The report must include dates of admissions, discharge, diagnosis, treatment plans, results of any drug or alcohol testing, prescribed medication compliance, and prognosis and recommendations for continued treatment. Each party was ordered to pay their own costs. Very important, folks, as evidenced in WB versus RB, Henriques J made it very clear that the privacy of medical records is not sacrosanct. The court can interfere in that patient-client confidentiality, or patient-doctor, confidentiality in the instances where it is required for a forensic care and contact investigation. Importantly, the court did endeavor to put in safeguards to protect the privacy, and I'll also say the dignity of the first respondent, in ordering that the records only be given to the psychologist and not to the applicant, which would, in my view, have been a big infringement of the right to privacy of the first respondent. Paragraph 33 is a very important quote from this judgment. In reaching the conclusion that I have considered the specific facts of this matter and have had regard for the various principles. and a cautionary word from the judge here. I hope that the order I issue will not be seen as a carte blanche order to be issued in matters of this nature, and must stress that each application must be determined on its own set of facts. I've had to consider the effect of the order and its implications for other litigants in forthcoming and pending litigation, and balance the competing constitutionally entrenched rights. WB versus RB, Henriques J saying, here is your judgment, do not abuse it, litigants in future. That is WB versus RB and another, now reported in the SA Law Reports all the way from the Durban High Court. Next up, we go to AO versus CO. That is all the way back in Johannesburg, and we are looking at Rule 43, AO versus CO, ZA-GPJHC 597, 20 June 2024, and this is under the pen of von Ludwig AJ, page 250. This matter, von Ludwig AJ had to look at the Judge President's Directive 2 of 2020, and for those of you practicing in Gauteng will know this as the now very famous FDF Practice Directive, which introduced the financial disclosure form or financial disclosure affidavit into our law, lending or borrowing quite a bit from the English family courts. Form E, I believe, is the relevant form. The matter was an opposed Rule 43 application where the applicant sought spousal maintenance and a contribution to legal cost. Various technical points were taken by one of the parties, and the court had to then examine whether the respondent was required to file a second financial disclosure form for the Rule 43 application. This is the nub of the matter. The directive says that a certain amount of days after filing of a plea, FDSFs must be exchanged, reciprocal exchange, very importantly. And then the directive also says in Rule 43, FDFs must be exchanged. And the question that the court had to answer was, if you have already done a financial disclosure affidavit in the divorce, must you do a second one for the Rule 43? And the answer by von Ludwig AJ is in the negative. If you have already filed a financial disclosure affidavit in the divorce, there is no need to file a second one. And a very important, I suppose, before I get there, for those practicing outside of Johannesburg, it is worthwhile to read this judgment of AO versus CO to get a good understanding for the time periods relating to the financial disclosure affidavits, which von Ludwig AJ did a good job of setting out in the judgment, and what the practical implication is in respect to those filing periods. The matter was postponed sine die to allow the applicant to reply to the respondent's Rule 43.5 affidavit. Now, the judgment itself, or the outcome itself, not having much to do with the financial disclosure form itself, but the principle set out very clearly in paragraph 13 of the judgment. The FDF is one of the many tools of litigation. Early disclosure by FDF can assist family law litigants to achieve correct results sooner and more cost effectively than they would without it. And very importantly, she goes on to say, but the FDF is not the only or even the most important tool in every financially oriented divorce. Hence, one FDF is sufficient to achieve its purpose. And I suppose also the rest of South Africa waiting for bated breath for financial disclosure affidavits to be introduced in their divisions. I know a lot of people, including some in the room today, are very passionate about getting these incorporated. Next up, third last judgment, folks, and our last three are all Rule 43s. LEA versus AJA ZA-NWHC 142, 21 June 2024, under the pen of Mfenyana J, page 262 of your bundle. This is from the Northwest Division, Mahikeng. A Rule 43 regarding care and contact. The care and contact portion was settled. Then spousal maintenance was looked at, and a contribution to costs was looked at. What I've endeavored to do, folks, in financial Rule 43 issues in terms of my summaries, and I'll show you here what I've done, is I've endeavored to, in the third column, to set out what was asked and to juxtapose it with what was given in terms of the final order. So in this instance, as you can see on my summary, which I've shared with you, which obviously you can pick up on Shopify for $250, which also gets you a CPD certificate. The applicant sought maintenance of $68,430 per month. The court granted $45,510. Wanted a contribution to costs of $100,000. The court gave $100,000 over 5 months at 20,000 Rand per month. So just so you can see how I've decided to do those in future, I find more often than not, we see quite a lot of Solomon approach happening in the Rule 43 courts, with split the difference between the tender and what is asked, and everyone walks out unhappy, which obviously is quite a problematic approach sometimes, but one can only put yourself in the hypothetical shoes of a judge called upon to adjudicate the Rule 43 with very abbreviated information. Very interesting judgments or quotes from the judgment, paragraph 32 and paragraph 48 in turn. It is tried that the adequacy of maintenance needs largely depends on whether such requirements are necessary and reasonable for the sustenance of the applicant and the minor children. The maintenance needs of the applicant and the minor children are no doubt influenced by what they are accustomed to. By all accounts, they were living in the lap of luxury. The minor children have also become accustomed to this standard of living. Then paragraph 48, in terms of the costs contribution, I must hasten to add that while it cannot be denied that both parties have access to sources of income in their respective capacities, the applicant has demonstrated that she is not able to litigate at the scale at which the respondent is and would be outwitted financially if a cost contribution was not ordered. In this instance, the applicant having access to some funds but not sufficient funds, the Rule 43 contribution was granted. Next up, we go to LEA versus AJA, and that is, my apologies, let me just quickly get back to where I need to be. Sorry, this is a duplication. We've just done LEA. Next up, we've got SK versus MN, back down to the KwaZulu-Natal Durban High Court under the pen of Davis AJ, our penultimate judgment for the day from the June Family Law Roundup. Page 282 of your bundle, ZA KZDHC 43, that is SK versus MN from the Durban High Court. The matter revolves around Rule 43 for interim maintenance. There's a contribution to costs. There's condonation for late filing of an affidavit. And then also the court looks at prolixity and has quite a lot to say about the prolixity of the papers. The applicant sought interim maintenance, 108,000 Rand per month. As we know, lifestyles of the rich and famous down in the North Coast. A furniture allowance of 171,000 Rand. And surprisingly, a contribution to legal costs, which in comparison is quite measly, of 50,000 Rand, pending divorce. Usually when we see maintenance reaching the hundreds of thousands, we often see the contribution to costs wish list going far in excess of 1 million, but in this case, 50,000 Rand. The respondent opposed the Rule 43, instituted a counterclaim regarding primary residence, and that was not too much in terms of, not much vigor behind the counterclaim. and probably done as a tactical counterclaim. Court examined the financial disclosures and the need of the applicant and children. For Cara, who's asking for the name of the case again, I'll repeat it. SK versus MN. Case number D3532/24, Durban High Court, obviously. 2024 ZAKZ DHC 43. And that is SK versus MN. The previous one was LEA versus AJA. I'm not going to give the full citation again. It will be up on the recording if you require it. So the principle in SK versus MN is that Rule 43 applications aim to ensure that no party lacks the resources to maintain a reasonable standard of living pending divorce. And it also says that condonation is not simply for the asking. Ironically, condonation was granted in this instance. So maintenance was granted in terms of Rule 43, 108,000 asked for, 55,000 given. Very close to a Solomon approach plus change. Then furniture asked for 171,000, 50,000 was given. 50,000 asked for in terms of contribution to costs, 40,000 given. And a very nice quote on counsel's analysis of the financials, and this is the best strategy in Rule 43, as we know, folks. The court says, counsel for the applicant has subjected the respondent's financial disclosure bundle to searing and unforgiving analysis. The analysis reveals that the submissions made by the respondent in his affidavit are at best extremely misguided. At worst, they are quite simply a disingenuous attempt to obfuscate his financial position. And that is the only way to go with Rule 43 is analysis, analysis, analysis. Whereas some of the submissions in opposition to condonation being granted are not without merit, the respondent's explanations on certain aspects inadequate. Regardless, it is in the interest of justice that condonation be allowed, primarily on the grounds that the matter concerns the best interests of 3 minor children. His application raises important issues pertaining to their well-being. The prejudice to the applicant was, in my view, insufficient to warrant the refusal of condonation. In all litigation involving or concerning children, the best interests of the minor children affected are paramount. It must be properly ventilated and considered. It is for these reasons that I granted condonation. Quite interesting that it almost, whilst the court says, condonation is not just for the taking, the court also says, well, there are kids involved. It raises issues regarding the kids, so condonation is given. The court also, in that instance, and I haven't highlighted it in my summaries, gives quite a scathing criticism on prolixity of papers in Rule 43 and how Rule 43, which was designed to be expeditious, has become very onerous and very bloated in its very nature. And then our final matter, folks, SM versus SMM, and that is under the pen of Engelbrecht AJ in the Johannesburg High Court, bundle page 299. Our citation is 2024 ZAGPJHC 558, and this judgment landed on the 7th of June 2024. It was a Rule 43 for interim maintenance contribution to costs and a request that the attorneys for the respondent be ordered to pay costs de bonus proprie for 2 appearances at court. The applicant sought interim maintenance for a major dependent child of 10,000 per month, a 40,000 Rand contribution to costs, and then obviously the costs order de bonus proprie. Respondent opposed the application. What had happened is the respondent's attorneys failed to appear on 2 occasions. I think it was the 27th and then the following date, the 28th. The attorney working with the matter was late stage in her pregnancy and wrote a letter saying that she would be going for a cesarean section, not necessarily an unreasonable circumstance for that attorney not to attend court. The court, however, did point out that the attorney in question was from a firm with various other attorneys who, it was stated, were on holiday of the time of the Rule 43 application. The court was not very happy with that. So what had happened was a costs order bonus propria was granted against the attorneys on scale A. Interim maintenance of 8,000 Rand was ordered as opposed to the 10,000 asked for, and a contribution to costs of 20,000 Rand was given in 4 installments where 40,000 was asked for. Restating the principles of postponement in paragraph 6.11, the court says, where a postponement is sought, it is determined at the court's discretion. A party seeking a postponement must demonstrate a full and satisfactory explanation of the circumstances grounding the indulgence. And then also paragraph 13.5, we have the court saying, I am of the firm belief that the respondent did not provide the necessary and required financial information with the sole purpose to ensure that this court would not be placed in a position to determine his exact income. As a result thereof, the respondent did not provide all bank accounts, does not explain how his own income or expenses, and how it is paid or even was paid, does not explain what is paid by the business on his behalf, such as petrol, groceries, meat, and legal costs, or place before this court sufficient information pertaining to the rental income of 35,000 Rand. This then left same to the court to do, which conduct should be frowned upon, and obviously a factor taken into account by the court when granting the Rule 43 order. So folks, that concludes the Family Law Roundup, June 2024, an eventful one with power outages and grave risk of harm to landlords in office parks, which I will give feedback on. For those of you not yet part of the ThinkLegal WhatsApp groups, please join us, and you can go to thinklegal.co to join us on the WhatsApp groups. Reminder of Divorce 101 taking place at the end of July, I believe it is. The link shared in the chats. Please do register for Divorce 101. 6 CPD points underwritten by Psalm for 3 nights evening classes. And then finally, please do pick up the course bundle for today. It gets you 2 CPD points with Psalm and social justice, and also it helps Nadia and myself to prepare this webinar every month and to keep attendance to the webinar free of charge. From myself and Nadia, thank you so much to our supporting entities, Vermeulen Attorneys, obviously, and Lawbox Practice Management Software for lawyers by lawyers. And most of all, thank you to everyone who has taken the time to watch this live stream, and for those watching at a later stage on YouTube. I wish all of you a wonderful weekend, and I will see you at the next Family Law Roundup, the first Friday being the 2nd of August 2024, where we will be looking at the July Family Law Roundup. Thank you again for attending. Have a wonderful weekend and see you at the next one. Cheers, everybody.